Thank you. We're going to start off with the initial consultation, and what we titled this on the agenda was when to listen to the client, when to speak, and when to shut up. And the nicest way of starting with this is when people come in with a criminal case, understand that they're not calling you because they've had a good day. They're calling you because their lives are in jeopardy. Some of your clients are going to be paycheck to paycheck employees, so they're already missing work to meet with you, and so they're worried about that. They could be worried about jail time, who's going to take care of the kids. They're worried about getting fired from their jobs. So their stress level, as opposed to just dealing with the criminal charges, fines, and consequences, have to deal with those collateral things. Normally when the clients are coming in on a criminal case, they're going to show up right on time. They can be late. They get lost. They don't need you judging them because they got lost, or maybe they couldn't find parking, or maybe they were running late. They are coming in with just a variety of emotions. So when I introduce myself, I always tell the client, this is my name, this is where I graduated from, here's a little bit about me. I try to do a really good job of, when I'm meeting with the client, to figure out how nervous they are, what their mood is. Sometimes it's best not to get into, well, why are you here today? It's better to ask them, tell me a little bit about yourself, because they want to be treated like a person. Everybody has some type of association with what they think a lawyer is going to be like. So the least lawyer you can be, I always advise, get to know them as a person. Are you married? Do you have children? Tell me about your job. If they say, I work at Valmont, what do you do at Valmont? Tell me a little bit about your daily. That way it gets them to relax, and it helps them to understand that you actually have an interest. In criminal defense, you're going to be asking people, obviously, to pay a retainer. And sometimes these retainers are more than they make in a given month. So the more that you can try to connect with that individual, the better, because they're already worried about how they're going to pay you as well, and probably already have in their mind an idea of, I have to hand this man or this woman a month's salary up front, and they're thinking about that. Listen to the client when you're talking to them about their charges. They may be very angry about the way they were treated about law enforcement. This is not the time to interrupt and say, but the traffic stop was good, so let's just get off that. That's the part where you need to shut up. You need to let them vent it out. They're angry. They're angry because they got pulled over for a DUI. Their house was 3 doors down and the officer towed it. Let that client vent it out. They want to be heard that it was unfair that they had to pay a $300 tow. And so those are important things of realizing, yes, it probably means you can't get the tow charge reversed. No, you're probably not going to win that DUI, but it's important for them to have you listen and understand those types of issues. Sometimes people they're very angry about the way law enforcement treated them just in general, whether they're being rude. And so it's okay to tell that client, I understand you're frustrated. Tell me what specifically was said. And listen to those things so that way you can tailor your legal advice accordingly. Because sometimes they know they're going to go on probation for the DUI, but they want to be validated about what they're angry about. When they're talking, and I use a lot about DUIs because that's usually in criminal defense, your entry level case is going to be a DUI. It's going to be a misdemeanor. It might be a shoplifting, bad check, those types of situations. I tell people that are newer to criminal defense, felonies are not where you start. You need to start in misdemeanors because you're able to get used to the clients, you're able to get used to what it's at stake, and you're able to get involved in the process. The ramifications of a motion to suppress in a misdemeanor case where the maximum punishment is up to a year in jail and a $1,000 fine is different than the ramifications in a motion to suppress felony case of which somebody could be facing life in prison. So although as a newer attorney, it may be interesting or it may be exciting when somebody calls you for that felony burglary or a felony kidnapping, those are definitely not the cases to start with. You need to start in the very beginning with just the misdemeanors and to get that. I speak up towards the end of a consultation. My consultations normally take an hour in my office. And so towards the end, if a client is rambling and they've made the same point 3 or 4 times, there is a time to speak up and explain to them exactly what you think you can provide for this client. I actually got this advice as a newer lawyer from a family law attorney in town. And they always ask their clients, what are your expectations? And I think that is the number one thing that you have to ask your clients. What are your expectations? I actually write it down in every file that I have of what that client's expectations are. It can vary from, I don't want to go to jail. I want to beat the charges. I would like to not appear in front of a certain judge because I'm scared of that judge. I've appeared in front of that judge too much. Once you understand their expectations and you're representing them, when they call you and they're angry about something else and they're mad that they have to do 7 days in jail, you can always go back to their expectations. Remember when we first met in my office and I asked you what your expectations were? Your expectations of me were, please, 7 days in jail. I don't want to do probation, and promise me I don't have to go to jail for 60. And clients will respond to that. Give them time to hear you, and they will say, okay, you're right. I did tell you that. I didn't want to do probation, and I didn't want to do 60 days. So those things I think can be important.
Yeah.
Kenny, you got the floor.
So I guess what I kind of do on initial consultation as well is you're always going to have like a parent or a significant other want to set in on a consultation. What I will do is I will break it off and I will say, listen, if you could wait here in my waiting room while I meet with the client, the defendant first, then I will gladly have you come in after we discuss it and I'll answer any questions. The reason I do that is to protect attorney-client privilege with my client, not necessarily their significant other, their parent, because like Des said, on a DUI case, you might have one person that has an expectation and a parent or a significant other that has a much higher expectation. So what I try to do is speak with who will be your client first, and even if the other person is paying, the client is always your client, not the person paying. So I try to speak with the individual first, and then I will bring in the other person, whether it be significant other, parent, whoever it may be, and say, all right, I can talk to you about things that are public record, what charges are, what you're facing, when your court date is, that sort of thing, when your next court date is. But I will not talk to you about what client I discussed in the consultation. I also will advise the client of all the rights they have. I'll just say, hey, listen, when you go to court, the first time you go to court, the judge is going to go through this and spout off all the rights and what the potential penalties are. You don't have to agree with what the penalties are, and you don't have to agree that this is the charge, but the judge will ask you if you understand it. So I kind of do that as a way to kind of get them ready for their first court appearance. Even if you have them sign a written not guilty plea, which that I think basically every county around here, Douglas, Sarpy, Washington, Saunders, Cass, I believe they use those now as a way, instead of going to the first appearance, I'll just have my client sign a written not guilty when they're there. Even if you don't have a case number yet, I'll go back and fill that case number in later just so I have that, so I can say, listen, we're not going to have to go to your first appearance just for the judge to advise you of your rights and for us to plead not guilty. Me filing this will give us time to get the discovery, to go through the reports, to watch any videos that there may be. Because if it's a consultation on a DUI client, I tell them, like, I don't necessarily ask them what their expectations are, but I will say, this is what I do. On a DUI, I watch for the reason for the stop to see if the reason for the stop's valid. Then, I'll look and I'll watch the videos to kind of see how you walk and talk is what I call it, and see if that kind of matches what the test result is, and then take a look at the machine and the calibration and make sure it's properly calibrated. So I try to, like Des said, set out the client expectations, but tell them what I'm going to do for them if they retain me on this DUI case. And I think that kind of transitions into the case review portion of it, which is, obtaining reports, watching videos, talking with witnesses, checking with witnesses. First, I guess, for basics, how do you go about getting the reports? In Douglas County Court, you can look it up on FileBound. You have to get access from the city attorney's office to access FileBound if it's a DUI, a shoplifting, basically anything that's not a domestic assault case. If it's a domestic assault, or if it's like a trespassing with a domestic stamp on it, is deemed that. Then you have to reach out to the county attorney's office to get the reports. You can certainly file motions for discovery to get all the reports, but generally on the city attorney, they use that FileBound system. They will upload the reports under the RB number, which is like the citation number. So if somebody brings in the citation, you'll see like an RB number at the top. Generally, what is it, like OP something?
Yes.
And you can get on the FileBound system and download the report specifically. They also have on FileBound the Brady material on the officers. So Brady material is any officers who maybe have had
Giglio.
Giglio. So any officer that's maybe testified falsely at a different hearing, there's an order of that, and that will be found under that officer's, I think, badge number, if I recall correctly, on FileBound. So you can get it that way. So that's generally how you obtain the reports. In other counties, if you file the motion for discovery, I think they will set it for like a dummy date, is what I'll call it, where no parties actually appear because the prosecutors don't have an objection to the discovery. So the judge will just enter an order of discovery saying, county attorney, comply with rules of discovery, provide everything you have to the defense attorney. Once you get that, reports, obviously, I review the reports. If there's videos, do you have to watch every single second of every single video? If there's 20 videos on a DUI stop, probably not. Like I said, what I generally do is take a look at the reason for the stop and see if that's valid or not, and then take a look at how they walk and talk. If this is getting, I guess, a little bit outside of basics, but if you get higher level felony cases, it might behoove you to watch the videos. And I did an appeal or a post conviction a couple years ago on an attorney on a child pornography case, and the attorney indicated that they did not look to see if it was actually child pornography. And as much as it sucks, I kind of have the opinion that you have to actually look at it to make sure it's child pornography, because who else, if you're going to plead your client, a jury's not going to look at it to make that decision. A judge isn't going to look at it. So, she indicated on the record that she didn't look at it. So we did a post conviction based on that. And if it's a case that you don't want to take, then certainly, don't ask for a retainer. Just say, I'm not comfortable taking this sort of case. But on some of those higher level felonies like that, you have to do those. Just make sure that you're looking at those reports, watching those videos, potentially checking with witnesses and speaking with witnesses. So.
Do either of you video the initial consultation?
I don't.
I do not.
Or ask for permission to do that?
I do not. My thought is I always want to protect the attorney-client relationship, and I also don't want to be in a situation where somehow something happens to that video and it gets in the wrong person's hands. As criminal defense, we have a huge advantage because we never have to tell the prosecutor what we know. Like, we can hold it back. We can hide behind rebuttal evidence. There's certain requirements and stipulations we have to turn over. Yes, we have to we have to do alibis, but when we have a defense to a case, if it's a case of, I had a case early in my career, and it's kind of going to tie back to the initial consultation when clients are talking to us. And I was over in Sarpy County, and I was a public defender at the time. And one of the things is we had this client that came in, and she said she was accused of stealing her girlfriend's lawnmower. And she swore up and down to me and the attorney. I was senior certified, so there was an attorney that was supervising me, and swore up and down to us that she did not take her girlfriend's lawnmower. And her lawnmower, the girlfriend's that got stolen, she left it in the backyard. And the fence was wide open, and so we were arguing with this prosecutor, like, you're never going to be able to prove it. Anybody could have taken that lawnmower. And so we were getting ready to go to trial. We had prepped this, and we're ready. I mean, we are excited. I'm going to win a case, and yes. And so the prosecutor calls us up and says, well, I'll dismiss the case, but she's got to pay $200 in restitution. And even though we know that they can't prove the case, by law, ethically, we have to give that deal to our client. And we ethically have to communicate, this is the offer they made. It is your choice whether to take it. This is our legal advice. And don't ever get caught in criminal offense not telling a client an offer, because you can get yourself in some big trouble, even if you think it's stupid.
Yeah.
So we called and we told the client, this is the offer. They're never going to be able to prove it. Don't do it. And our client responded back, what happens if I just return the lawnmower?
Still have to pay
So we got that one worked out. It was a big lesson to the other attorney and I, and we laugh about it to this day of, they will tell you some version of the truth, but it goes into that. Like, you read the reports and understand what your obligation is, but we can't tell the prosecutor in that case, hey, by the way, our client took the lawnmower. You got to keep that attorney-client privilege. And so those are things I tell people about. There's a difference between doing civil litigation and doing criminal litigation to a certain extent. And so what I do is, and I always tell new attorneys this, in Douglas County, when you sign a stipulation, and it happens in federal court too, you are signing a stipulation as the attorney that you will not release those police reports to any individual, including your client. And if there's a reason you need to release those police reports to your client, you're supposed to notify the prosecutor. Sometimes our clients can be their worst enemy. And so they want their police reports and then they disseminate them. And now we have more witnesses, because how am I going to prove that this person wasn't there at the scene 8 months before, who now claims this because they're mad about whatever? So I do not release police reports to my clients. Yes, there are clients that get mad about that, and they'll say, well, my last attorney or my friend's attorney gave them the police reports. Then you are more than welcome to hire those people. I can refund you my unearned retainer, but here's the stipulation I signed. I do not give out police reports.
You're showing them to them, but they're not taking
Right.
them.
Correct.
Yep.
They can review them in my office with me. Yep. They can call me up. I'll read them to them. I can do all those things. The other thing with FileBound is when you sign up for FileBound with the city prosecutor's office in Omaha, you are thereby signing a declaration that you will not access the police reports of any case that you have not been consulted or retained on. And that is a very huge deal. If you get caught looking up somebody else's case, you want to be nosy, and you get caught, they can revoke your ability to look up cases on FileBound, which means you're going down there and paying like $0.25 a page or something like that. I've heard that attorneys have gotten in trouble for it, so just follow the rule and only access cases that you're supposed to be looking at. Something might make the headlines. It might be an attorney that you want to look up. Don't do it, you're not supposed to, and they can check with your passwords to know what you looked at. So honor what you're signing. That's a really good thing that can get you in trouble in Douglas County.
Can I ask another question on initial consult? So after the consultation, do you write a letter memorializing that, or is it just kind of retainer agreement that you send them, or both?
My practice is I will send them a letter, like an engagement letter saying you've agreed to retain me for this case in this county, just so you kind of have that for your records down the road. And then I guess the same can be said when a case is over, so for instance, somebody goes in, pays a $200 fine and gets their case dismissed or whatever. I will send them a letter saying, you entered a plea on this day, or your case was dismissed on this day. This ends the representation. Here's a copy of the order, sentencing order, order of dismissal, whatever the case is, and send that to them. And I'll say, I've been burned on this, or I've not burned, but I've been had to testify at a deposition about this because clients will say, well, you didn't tell me I had the right to an appeal. So in my letter that I use, I say, this is what you were sentenced to. For instance, if it was a felony reduced to a misdemeanor with probation or whatever the case is, I'll say, you have the right to an appeal. I don't think there's any issues to appeal because you pled guilty or no contest. This was your sentence. If you feel like you have any issues you want to appeal, let me know within quicker than 30 days. But let me know immediately so I can get that paperwork on file. And then at least I can get that on file. And my retainer agreement specifically says, this retainer is only for this case, does not include any probation violations, motions to revoke, or
Other
appeals.
charges.
Yeah.
Or
Or
other
other
charges.
charges. Other charges as well, yeah. So
That happens too.
that happens too. Great.
I do a
So-
fee agreement. You don't want to fight with a client on money. And the other really great advice I received when I became a lawyer in private practice only was get paid first, help second. And I think every attorney in their practice has ended up in a situation where a client hasn't paid them. And so the easiest thing is to get the retainer up front, be honest about it, and then don't be afraid to enforce it. Sometimes I wonder what I really sound like when other people may overhear me have to have the tough conversation with the client of, you owe me this money. The retainer is out. You receive the monthly bill every month. You know it's out. You have to pay me. If you don't pay me, I withdraw. Here's the fee agreement. It's that simple. I'm not working for free. And if you don't do it by X date, I'm withdrawing. And that is something that's really important in the legal community, is you have to have the reputation of enforcing those fee agreements. Because if it gets out there that you don't enforce them, you're gonna get ripped off a lot. And you work with people. If they're a couple $100 behind, let's use some common sense, right? But if they're getting way behind and it becomes obvious this is a problem, then you need to communicate with your client and have those discussions. I have often found if you don't ask, you're not going to get paid. And so you need to stay on clients about that.
Can you do a retainer with an hourly rate?
I do.
You don't do flat fees for anything?
I don't do flat fees anymore. There are criminal defense attorneys that do flat fees. You can still do. Apparently that's him. I don't. What I found is when it's harder and harder to predict with some of the counties with how they're doing their caseloads, if I'm going to be there for an hour or if I'm going to be there for 4 hours. Sometimes you draw judges that take a little bit longer to do things with their caseload than other judges. And so my time, I'm a solo practitioner, so my time is money. So I have to make sure that I'm being compensated for every minute. When clients ask me, why don't you do flat fees? Well, there are some times when I can get a case disposed of pretty quickly and you would have taken the loss. Do you want to take the loss or do you want me to take the loss? I don't really want to take a loss on it, but that's why I don't get involved in it. And clients understand. I have it in my fee agreement. If I don't earn this, it gets refunded. So they'll get the money back. And I'm very clear with them. Your chances of getting money back if this case proceeds with litigation is pretty slim. Yeah. So I explain that to them and also what the costs of trial are. So I think that's a big mistake some newer attorneys make is they're stressed. They got to make that rent payment and they, for their office, and they need to pay their paralegal. So they'll take a case for $5,000, but it's in Hamilton County. That's in Aurora. So what are you doing? You can't even get through 1 or 2 hearings by the time you do your travel costs. And now you can't get out of the case and you're chasing money. So I tell clients, I tell attorneys, if you start taking cases because you need the money, you will remember the state V for the rest of your legal career because you will regret, why did I do this? I knew it. So trust your gut instinct. It's not indigestion. If you're thinking this person's going to be a problem child, guess what? You're going to make the same amount per hour if they give you a migraine or if they're going to be cooperative. So if you're getting that feeling, then that shouldn't be, just stay away from that case.
And I kind of mix it up. I'll do some cases hourly, some cases flat fee. just kind of depends on the case and the location of the case as well. Especially like I took a retainer for a case in Madison, and I was like, I am not doing this flat fee because I have zero idea how many times I'm going to be driving, essentially 2 hours there and 2 hours back to Madison. So I did that one as an hourly rate. So it just you kind of get used to what you're comfortable with. And if that's flat fees, then that's fine. And if maybe it's fine. I think there's an opinion that's soon to be released from the ethics committee.
I think we'll hear.
On flat fees for
for criminal.
For criminal stuff. Yeah,
What
so
do you
I'm
do
sure
with
we'll
the
hear
client
about it.
that You find out lied to you.
that happens
You
all the
mean every
time.
client?
Just for the viewers at home, that was from the audience. I think a lot of the lying goes to being scared. I can't imagine what it would be like for some of the clients that have found themselves in situations. And so after I get to officially say I've been a lawyer for 20 years, so I'm pretty excited about that. So in the 20 years of doing criminal defense, I learned that sometimes people don't mean to lie, but they're embarrassed. And so they're going to tell you, I really didn't shoplift, because they're embarrassed and they know they're going to lose their job. And it's just kind of a thing that they do. So I don't sit there and say, well, that was interesting because you told me you didn't do it, but look here at the Shields video, it's you. How I handle those situations is, come in, let's look at the Shields video. We watch the video, and then I say, based on this video, I don't think I'm going to be successful at trial. So I'm going to advise you to do the diversion, even though it's going to be really painful and you're going to have to miss a lot of work. I just can't win. I don't ever confront them about you lied to me. I just think that's not, people don't need that.
And some of it too is also not necessarily just straight up asking them like, hey, what happened? You can save that for later after you get the reports. You can review the reports and say, this is what's indicated in the reports. Does that sound about right? Without like just straight up asking them, hey, what happened? Because then if they lie to you at your initial consult, then you can't, if you end up going through with the trial, you can't put them on and have them testify to something that they've previously lied to you about. So I try to kind of cut that off at the beginning sometimes by not necessarily asking them what happened or not necessarily talking with them about the facts, detailed facts at the very beginning, but wait until I get the reports. If they want to talk to me about it, I say, listen, I'll get the reports, I'll get the videos, then we can sit down, we can talk, we can go through all those, we can talk about everything at that point in time. Like Des said, I don't make you can't make copies, and I actually prefer not to make copies for my clients because it's never ended well whenever a client gets a copy of a report, in my experience. So.
No,
I have a question. So say for the new criminal defense lawyers, they're just starting out, and someone comes into their office. And maybe has this ever happened to you where the person paying says to you, why shouldn't we get a public defender? What can you do for us that a public defender couldn't do?
I get that.
Explain.
I get that fairly often. I mean,
I do too.
I tell them, I was like, I can't tell you what they would do different than me, because frankly, I was a former public defender. I was a public defender for 6 years, and they're some of the best attorneys in the criminal realm because they deal with that all the time. What a lot of people will complain about is they don't have time to return my phone calls or whatever the case is. So I'm like, I might not be able to do anything different than what a public defender can do. They're great attorneys, and I'm not going to say anything negative about them because I was one. However, I feel as though the difference is I've been able to return calls quicker or in a more time efficient manner than when I was at the public defender's office and in court from 9 to noon and 1 to 4. So.
And I suppose you get to choose the cases you want versus public defender has to take everyone that comes.
Yeah. Unless
So-
yeah.
I was a public defender or at the public defender's office for 10 years. And so you're assigned cases. They don't have, in my experience, the same type of decision making that if I don't want to take a case, I don't take one. It's harder when you're a new attorney because you have to take some cases and you might say, I really don't want to take this stuff case. But you got to you're not going to have everybody coming in that you're going to get a not guilty for. I think some of the best experience I had is because I was a public defender and because I had to try trials with people that said, I want a trial. And so I had to try it. You know, what people would say, those are bad cases. You should not have tried that. Well, guess what? It taught me when to object. It taught me my style as an attorney. It taught me how not to freak out when things change at the last minute and a client says, you know what, I don't want that plea. We're here for trial, try it. I don't freak out. I can do that. I know how to do a DUI, and I know how to represent people in that capacity, and sometimes you can't work out a deal at a trial, and so you got to be able to do it on a fly. I never talk negatively about the public defender's office. They are incredibly overworked. I think they have a huge caseload, and when people ask me, well, kind of the same questions, when you hire a private attorney, you're paying for the convenience of being able to call that person and get a phone call returned the same day. That can't always happen with every public defender. Even when I was a public defender, I had the rule of I'm gonna get all my phone calls returned. I tried, but sometimes when you have 3 jury trials in a week, you're not getting those phone calls returned. So I always say, don't even if it were, I'm shopping around. I have this attorney, and I don't care if that attorney has a worse reputation in town. You never say anything bad about another attorney, because guess what goes around comes around, and you wouldn't want them saying something bad about you. So don't get involved in that. And if somebody calls you and you know they're a really great attorney and they're talking bad about them, then that's your warning sign of don't get involved. That's not indigestion. That is your warning sign. I actually watch all the videos. I just want to touch for the new people out there. I actually watch all the videos. Sometimes to me, it's not about a stop, but there'll be an officer on a different video that'll make a statement. And if I didn't watch that other officer, I wouldn't know that there was a question about whether the blinker was on. And so sometimes I know it's time consuming and it takes a long time, but I think attorneys can get themselves burned by not watching videos. So you got to
In
be
my
careful
defense, I had a case recently where the person was stopped for not using their blinker, and then they searched a car and found drugs. But I watched the first minute of the video and I was like, blinker's clearly on, quit watching the rest of the video, talked to the prosecutor, and they're like, yeah, we'll dismiss that one. So I didn't have to watch the full amount of the video
And
for
sometimes
that.
Sometimes that happens. And there are attorneys that don't watch the videos at all. And then it's like, what are you doing?
Yeah.
Because if you don't watch it, you don't know what you don't know.
Right.
I had a case where they accused a nurse of stealing medicine from the medicine room at the hospital. And I just didn't think she did it. And I got the videos and what the woman that worked at the hospital and what the investigator said happened on that video. And I had a preliminary hearing on it. I lost, but I filed the plea and abatement, and then I get the video in Douglas County because that's the way they do it. You don't get your discovery till after the hearing. And I watched this video, and nothing that they said in that report happened the way they said it happened. And so I wish at the prelim I would have asked the investigator, did you personally watch the video? Because he would have been on a Giglio list had I asked that question instead of the way I asked the question. And so he kind of got to worm out of it. But that's not what happened. And so that I called the prosecutor and I said, listen, please watch this video. It'll take you about 15 minutes. Please watch it. It didn't go down that way. That prosecutor did watch the video and she did dismiss the case and there was a discussion about, and Giglio is where law enforcement lies or there's some type of fraud, and so they have to disclose that to you.
Do your clients ever write bad reviews on Google, and if so, what do you do about it?
You ethically cannot reveal attorney-client privilege. You hope that people in this day and age take it with a grain of salt when you get a bad review and people look at it and they realize, wait a minute, that person doesn't seem logical, or that person probably isn't telling the full story. I think negative reviews that I have seen, or going to CLEs and we hear about them, if you don't return phone calls, you are going to get some bad reviews. Return your phone calls and communicate with your client. Even the bad news. I think sometimes attorneys are scared to tell their clients, I can't get the case dismissed, or I can't get you out of jail time. And so they just don't tell their clients, and then they wonder why a bad review. So just be transparent regarding that.
The other thing that Des pointed out a little bit ago was, relaying offers to clients even if they don't want to take it. So ethically, you have to relay every offer. So what I will preface it as, a lot of times I will tell clients, hey, listen, I understand that you want to have a trial on this, but my duty is to tell you this offer, and the offer right now is X, Y, and Z. Plea to this with an agreement for time or probation or whatever the case is. If you don't want to take it, that's fine, but I have to tell you what this is, and I at least have to advise you of that offer so you know what it is. I've also had clients in the past where I think it's an offer they should take, and we're in the middle of a trial, so I know that some people have very strong opinions about it, but I have put that offer on the record instead of looking at up to life in prison, like on a child sex assault. Hey, I just got offered a child abuse 0 to 3. It's like put that on the record, because I don't want to have to face that later down the road. And when I put that on the record, it's with like just the court reporter, my client, and myself, and nobody else is in there. So.
And there are some times that I've been involved in cases where the judge will actually say, I want the plea offer on the record, and the plea offer, and then the client can formally reject the offer on the record. And I tell clients that they don't want to take the offer, that's fine. I'll get it in writing from them so that I've communicated with them. Your role as the attorney is not to be the client, and the client's role is not to be the lawyer. And so I always, in my initial consult and throughout, will say, my role is obviously one of as an attorney. That means I will never make a decision in a criminal case about whether you have a jury trial, whether you have a bench trial, and whether you have a trial period. I never get to make those decisions. And that is a very, very important distinction. If your client demands a jury trial, you must do a jury trial. If your client, against your legal advice, does not want to do a jury trial and they want to do a bench trial, that is their right to waive. They don't have to follow your legal advice. And likewise, they don't have to take a plea. And so that would be me doing their job if I'm sitting there forcing it down them. So I tell them, you always get to make those decisions. Now, you don't get to be the lawyer. So you don't get to pick which witnesses are testifying. You don't get to ask the questions, and you certainly do not get to decide what questions are asked. You can have a little notebook and you can write things down. Please don't hit me, grab me in the middle of a trial. It startles me and it weirds out the jurors. But just, they can be involved. But what you don't want, and I've seen it happen, where in the middle of a trial, you have people that are hitting the lawyers, and then they're like, you need to do this, you need to do that. It's distracting to the judge. Now they're missing the key evidence, and it's really distracting to the jury. So just make sure you lay that out. And clients, they get it. They do. I've only had a couple that have been, but I don't deal with that too much anymore.
When you offer the plea or convey the plea offer, clients go, well, what would you do? How do you guys handle that?
I say ethically, I can't tell you what I would do. What I can tell you as your lawyer is the good, the bad, and the ugly. So the good thing about this offer is you have control. You as the client know what is going to happen. They're going to get rid of these charges, or they're going to reduce these charges. You're not taking a risk of having a jury or a judge decide whether they can prove their case. The bad news is you're admitting to something, right? So whether that be a no contest plea or a guilty plea, that's the bad news. You're going to have a conviction. The ugly part about it is we can't take this case in front of the judge because the judge automatically has to follow the law. They're not going to do we call it jury nullification, where we're trying to tug on the emotional heartstrings of a jury to get them to look the other way about what the law says. You deal a lot with theft cases. So you have a young mother, she steals formula. That's a case I probably would take to a jury trial, especially during a recession, because you're hoping to have another single mom or somebody that just says, why is everybody wasting my time? Like, why are you beating up on this lady because she took some formula? That would be a case, that you really have those conversations on and let the client know the risks and go forward with it.
And what I'll do too is I'll say, listen, here's what the offer is, and this is what, if it's a DUI, it's like probation or non-probation. You're likely to get probation on this type of case. You know, if it's an offer for diversion, you know, saying, hey, if you would like to do the diversion program, what I will tell a client is say, listen, there's not many things that I can guarantee. I can tell you if you complete the diversion program, you know, 6 months or a year, depending on which level it is, you will have that conviction dismissed and your record will be sealed. So I can guarantee you, if you think you can do the diversion program, that you'll have a dismissal. And that's like the one thing that I can tell clients is, you know, I don't make guarantees, but if you complete this program, it's a guaranteed dismissal. So,
Can you make counter offers to an offer in criminal cases?
Yes,
Yeah.
so sometimes you'll get an offer of plead to this felony and you'll say, no, we'll take a class 1 misdemeanor. Or what I tell people that are negotiating is if you always are asking prosecutors to dismiss charges, I think you lose some credibility and they get annoyed with you pretty quick. So unless you got a reason to get this thing dismissed, don't be that person because it's just weird. But I think with counter offers that can be, and keep in mind, you're going to have other cases with these prosecutors. And the nice thing about Omaha is it's a big town, but it's a small town. So especially in the criminal defense field, we pretty much all know each other. And there has been some turnover between prosecutors that come be defense attorneys and defense attorneys that go be prosecutors. So I think don't take a case and then blow every relationship you need to have with people. And that means don't make it personal, okay? And I think a lot of young people will come out and they'll get into it and then they'll say, well, I'm never gonna give that person a deal again. Oh, well, it's a small world. That's probably not gonna work and we don't need to have lists. I can honestly say after 20 years, I don't have a list. And I'm very proud of it because Judge Hutton over in county court said, don't ever get a list. The best advice I can give you is don't put lawyers on a list because the minute you start putting lawyers on a list, that list gets really long and then you won't have anybody that you can go to. And I think in the criminal defense bar, especially with solos, we have to count on each other. And so if we have a family member that gets sick, you know, COVID, we all went through it, right? I had a list of attorneys that I could call and because I had a good working relationship and say, hey, I have to go into isolation. I have a court hearing in front of Judge Martinez. Can you please cover it? I'll get you next time. And the only people that told me no is because they were already in Douglas County Court. I always had somebody. But if I burned people or if I got into matches with people, with prosecutors, and now they're criminal defense attorneys and I couldn't get along with them, then those aren't people that I can count on. And likewise, I think I pride myself on that. If a solo is in a jam and they need coverage, they can call me. If I'm available, I'll do it. You know, it doesn't bother me. If I'm in the courthouse, I'll run over there and handle it. I mean, make sure you talk to your client and I know what's going on and they're aware. But I think that's one of the things that you need to do is just make sure that you're not, don't blow your whole legal career on a case because you're going to have others. And you don't know really what happened in some of these cases. I mean, I am amazed, aren't you, about how many he said, she said cases there are. You weren't there. Like, you don't know. So just don't get into these things with the prosecutors. The prosecutors shouldn't get into that with defense attorneys
and I
either.
think too is that's part of the professionalism. You can advocate for your client strongly in court, and the prosecutor should be able to do the same thing. But you should both be able to walk out of there afterwards and be like, hey, you know, talk about other things besides work. And you know, you don't have to like take every little like jab or like every little loss or whatever the case is personal with the opposing side. And I think that can be said for both the civil side and the criminal side. I just don't do any civil work, so
Yeah, it does happen on both
Yeah.
of them.
yeah. So
And I think that goes into, I remember when I was newer, there was always file a motion to suppress on every case. I don't file motions to suppress on every case. I only file motions to suppress when there's an issue. And so that has always done me well because when I do file a motion to suppress, I would say 9 times out of 10, I get a phone call from the prosecutor. What's going on? Well, there's a motion to suppress. I think it's a bad stop. I'm busy. What's wrong with the stop? Where's it at on the video? Or what do you know? And it resolves cases. So I tell people, you know, don't just be filing motions to file motions. It can ruin some of your credibility.
right, because if you If you're not one that files it on every single case, then they know, hey, I need to believe this attorney because they filed this. They don't file it, 100 times a year. It's only 10 times a year. So I need to look at the reason this motion was filed. So, yeah.
I mean, Doug, you used to be a prosecutor. Didn't you
Yeah.
do that too? Like, you knew the names. Yeah. We're doing audience
Yeah.
participation.
Yeah.
I mean, didn't you find that true as a prosecutor?
Yeah, I mean, especially when it was a motion to suppress and it was just kind of boilerplate. And you knew that they just threw it in there, their client wanted it. And then you may have to have a hearing, but then, it was just going through the motions and you didn't pay much attention to that particular motion because you know that there wasn't much merit to it, if any.
And I think with the prosecutors, sometimes on a motion to suppress, it'll be a good motion to suppress. And I've had prosecutors that have said, okay, we're going to have a hearing on the motion to suppress. It's not because I think you're wrong. It's because we have an issue with this officer and they're not listening to us. And those ones stress me out because I'm thinking, oh my gosh, if I do lose this motion to suppress, what do I do? And so you don't just thumb it in or just, you do your job and you still present your case. But that has happened and it has nothing to do with you're wrong. It's because they have an issue with a particular officer that will not stop pulling people over for X reason or, and so that's happened. And we all know who it is. There was an officer that was bad for a while. And so every time I had a case with them in Sarpy County, I would just file a motion to suppress and the prosecutor inevitably would read it, see the name, dismiss. So don't be afraid of those conversations when prosecutors are like, hey, I just have to do my job, and this is the reason why. I haven't personally had a prosecutor lie to me about that. It's because there was an issue and we're just trying to get through it.
And Doug and I had a pretty contested case when he was a prosecutor, and we get along great.
Yeah.
So,
Yeah.
I don't think I'm on his list.
Have you won any big motions to suppress recently?
Anything exciting?
Thank you.
Who's that police officer?
So I recently won a case in the 8th Circuit Court of Appeals as a criminal defense attorney, so I'm really happy about that. It's United States versus Sergio Jimenez, and that was here in the federal court system. I lost the motion to suppress in front of the magistrate. The Article 3 judge did affirm, but did a really good job in his opinion of saying that we had raised some serious questions about the constitutionality of what took place. And so I did appeal to the 8th Circuit and used that language and the video and pled the case. And then the 8th Circuit came back in July and in a 2-1 split decided that it was an illegal search and seizure. And they vacated my client's conviction, and my client is now out of prison. So it is very exciting on that.
And
Do you have a picture of him when he's leaving prison?
I do have a picture.
Just to
of my
follow up
client.
on what she said,
Get on my job.
for just the basics here, in federal court you can do like a contingent plea and still appeal. In state court you have to have either a jury trial or a bench trial. So what you'll see a lot of in state court is like a stipulated bench trial where people will just offer the reports. So don't expect to, if you lose a motion to suppress that you want to appeal, don't expect to plea it and then do an appeal. Just so everybody knows.
And in federal court, the prosecutors have a right to a jury trial as well. So even though your client may want to waive a jury, the government can force you to a jury trial. So it's a little bit different in federal court. The other thing is they have to agree to let you do the conditional plea. And so in my particular case, if I wasn't able to work out a conditional plea, I would have had to try the case, and most likely it would have been a jury trial. You try to do them as stipulated as possible, because that's the other thing. When you're doing jury trials, always remember, that person is probably getting, $25 a day? I think the fee is $25 a day. If they are a part-time worker, they are losing money by being there. And you need to be very, very aware of, yes, it's a civic duty, and you might be really excited for that jury trial, but if somebody is going to miss their rent payment, be respectful. And you just really have to be aware of some of those dilemmas that people deal with in jury that have nothing to do with your client. And so that would be my other advice. Just always be aware of that.
Doesn't everybody want to be on a jury now that they've seen the Amazon special?
No.
No?
No.
It makes me so sad when people try to get out of jury duty. I'm like, this should be so fun for you.
James Marsden's always gonna be there.
Please go back to the beginning.
Okay.
Tell the newer criminal defense lawyers cases to avoid.
Is this my way?
Yes.
Cases to avoid.
When they're guilty.
No, those
You-
are easy. It's the actual innocent ones that are hard.
I think don't take a case you're not qualified for. So that is a big mistake I see. And I don't want to say younger, I would say newer attorneys to the practice or newer attorneys to criminal law. They want to do a sexual assault trial. They want to do a kidnapping. And these are big retainers if the family can pay them. If you're not qualified, don't do it. You are going to spend the next 5-10 years getting post-convicted and contacting your malpractice insurance carrier.
So how about co-counseling?
So I like co-counseling. There's sometimes, I don't do it very often, but there's sometimes we do co-counsel. It may be a very large case. There might be a lot of witnesses. There might be an aspect of the case I really don't want to deal with. And I think, okay, I want co-counsel to handle these 4 witnesses. I just want to focus on these witnesses. Co-counsel can be good for newer attorneys, but you have to set boundaries. The client needs to know who the point of contact is. Is the point of contact Kenny or is it Desiree? When I've co-counseled cases, I was number B. So they knew any questions went to lawyer A. So lawyer A answered all those questions. We'd have weekly consults. We dealt with it. But what you don't want to do is client is telling lawyer A one thing, lawyer B the other thing, and then you're all confused about what's going on. So you got to make sure when you're co-counsel, you're communicating. When people come in and they say, and this is going to sound weird, I'm going to do the retainer, but I'm going to have this person pay, but we need your wire information. No. You're not getting my bank wire information. Go figure out a cashier's check. Go figure out a credit card. If they come in, again, sometimes it's not indigestion. If they come in and they got a credit card and you're like, who's that? Don't take it. Just get them out of your office. Sometimes the expectations are so unrealistic that you need to run because you're never going to make them happy. Or you do a justice search and you realize I'm never going to make this person happy because you can see post-convictions or stuff like that. The other good thing to do, especially when you're in private practice, is to figure out how many times has this person been sued for not paying things, because that's a good warning sign you're probably not going to get paid your legal fee. So you have to be careful about that. So in those cases, you might have to charge a higher retainer. It might be a felony that would be normally a $5,000 retainer, but because you see these judgments against them in the civil stuff, you know what, if I go to trial, I know this judge won't let me out. So if you want me to represent you, I'm going to need $15,000 up. So you have to be careful to protect yourself in those.
Do you do a justice search on every client before they come in for the first meeting?
Sometimes you don't have time. So sometimes it'll be a situation where you get a call, they're freaked out, the police have already called them, it's going to be the arrest warrant's going to issue, so they're rushing in, and so you might not have a time to do a complete justice search. You might just have time, get the retainer done. Who's my point of contact? Who's posting bond? How am I doing this, or what am I doing here? And so sometimes you don't have a chance to do it, or they don't have anything outside of Nebraska. They're not from here, so a Nebraska justice search won't show you much of anything. And the parent is not your client. So sometimes those are very difficult cases, but you have to make those boundaries very clear. And especially when it's an adult child, you have to make sure that's very clear.
Most of the time.
Here's a funny ending maybe to this. You pick up for a DUI. The cop asks you to recite the alphabet backwards. Can you force the cop to do it first?
They're
I would
not
not.
going to ask you to do that.
It's happened.
I tell my clients, don't make any
Not to me.
statements
Yeah, don't make any statements.
and don't
So-
do it. I wouldn't do anything.
Yeah.
I mean, in this day and age when they're saying, I want you to do this or do that, you're just giving them evidence against you. A, you're going to fail it. And B, you're going to sit there and probably smell like alcohol and it's just going to go downhill. I love my,
For years.
So just say no.
Just say
Just-
no.
just-
no,
I
the
know,
only thing you have to
respectfully
the only thing you legally have to do is when they say blow into the PBT
Yeah.
or blow into the data master, you do have to do that.
Yeah.
That's what you have to do to keep your license.
Let's take a big gulp first.
Well, then you're
Can
gonna
you
be waiting
start
another
with
15
any?
minutes.
Does that work? Any of those?
I don't think any of those things work, and you're gonna be waiting there another 15 minutes.
Yeah.
So,
Yeah.
and the best right we have is the right to remain silent.
Yep. Yeah.
Use it.
Use it, great.
Be quiet.
That's
Yeah.
great. Any more questions?
I know you've had sexual assault cases, and do you find it emotionally draining, so draining that you recommend new lawyers in this area to maybe refrain from taking sexual assault cases?
I think newer attorneys can get themselves caught in a situation where they know that a retainer could be very astronomical, and that's a lot of money. And so they think, because it's a $50,000 retainer, let's do it. And it is emotionally draining. Most sexual assault cases that I've been involved in, when I'm defending them, is a he said, she said, just depending on the genders of the parties involved. There hardly ever has been any direct evidence. And so I think they're the saddest cases. They're sad because only 2 people know what really happened. And I know I'm simplifying that. But it's sad because either somebody sexually assaulted another human being or somebody lied about being sexually assaulted. So in my opinion, there's never any winners in a sexual assault case. They are the worst, most horrible part of the human population. And so there's a reason I only take a certain amount of sexual assault cases a year, because they are so emotionally draining. As a defense attorney, if your client didn't do this and they're found guilty either by a judge or a jury, the chances are they are going to die in prison. And that is one of the most, I think, humbling experiences as an attorney, is to realize, unlike a doctor who deals with life differently, we deal with life in a different way. So I advise, it's one of the areas of law that I advise people to stay out of, especially if they don't have a co-counsel early, or if they're not, you lose a lot of sleep.
Yeah.
You really, really do. And it's hard because you'll have a child victim, and you need to treat any type of victim with respect. I've never been the type of defense attorney that felt it was wise to sit there and scream at people and act like how they do on some of the movies. So you need to be careful about that.
Yeah,
What do you
don't do a sexual assault case unless you have a lot of experience. Like, they suck. And I think they're probably the most tried case at, in Douglas County Courthouse. I would say that there's the most trials on those, because it's either the prosecutor just won't give you an offer because, their side
They
is,
can't.
I have to talk to the victim won't let me give you anything. And the other side is, like Desiree said, it's one person said something and one person says the other thing, because a lot of times, especially in like child sex assaults, it's a late report. It's never, right at the time it happened. So you don't have any physical evidence. So it's all just testimonial. So I think that those are the most tried cases. So unless you have plenty of trial experience, if you're a new attorney, I would honestly say just stay away from it. Experienced attorneys don't want to do them. So yeah.
And it's healthy to go to therapy for tough cases too. I mean, you can't tell them everything, but we are people. Attorneys are people. We have emotions. We have to deal with this too, right? And
Yeah.
you can tell your spouse about it, but you can go to get professional help, and that's fine too.
I have the running joke that I do retail therapy.
Yeah.
Retail therapy.
Terry will
You go
attest to
buy
that.
some more stuff.
I just
Yeah.
buy more stuff, right?
Yeah.
The Amazon man.
And it's actually not a joke, it's real.
It is real.
But I can also tell you that sexual assault cases, which Desiree used to do a lot more of than she does now, are incredibly emotionally draining on spouses.
Yes.
Because you hear about it at night, every day. This has happened. Oh, I've got to have the social worker say this. oh, they said this, you know, and you're thinking, this guy either did it, in which case, who cares? Or this guy didn't do it, he's gonna spend 50 years in jail because his stepdaughter hates him. I mean, it's, those cases are, I hope my wife never takes another one.
Yeah.
But the nice thing I think about having a spouse or having a family member is sometimes as a lawyer, you think you have this great legal theory. So you don't tell them who your client is. Like, they don't know the names. They don't know who these people are. But sometimes I'll say, okay, I have this case, and Terry, here's my facts. What do you think? What? Okay, we're not going to go with that theory. You know? So
Yeah.
it can be helpful.
Yeah.
But I do tell lawyers, if you're getting stressed out, it's okay to take a time out. It's okay to go seek therapy. Just, obviously it sounds cliche, just stay away from the alcohol and stay away from the drugs.
Sometimes it's okay to say no to cases.
Yeah.
Yes.
So that's some of the healthier options that you can have is just say no to a case because you know it's going to be draining later on, and even if the bank account hurts right now, it's going to hurt a lot more later whenever you can't practice because you're.
And to that end, like how are we doing right now? Do we need more criminal defense attorneys out there?
Are there enough to go around?
Denise Frost, and she will not care that I repeated this. She always had this great thing to say about Omaha. There's always enough room in Omaha for another good attorney. And I think that was just a sweet thing,
Yeah.
especially when I was entering private
Yeah.
practice. There's always room for another
Yeah.
great attorney. So that could be
Yeah.
the next new person.
Yeah.
Thank you.